The subject of our program is the legal tools that can be used in risk management and corruption. Before talking about these tools, risks must be identified. What are the risks in family companies? Family companies have some risks in addition to other companies' risks. These risks can be summarized as death, birth, first marriage, second and more marriages, polygamic relationship, legal separation, non-compatibility, irreversible coma, their inability to work, their disappearance, their conviction as a result of infamous crime. Furthermore, the risks may include having an illegitimate child, getting divorced, disposal of the company's shares, not having a successor to hand over the company, not having a successor who wants to take over the company. In addition, there are also reserved succession, corruptions, guarantor problems, having an inefficient board. Use of risk management in family companies. Legal instruments may include the main contract, inheritance, renunciation of the inheritance, marital of contract. In this respect, some similarities can be found between the main contract and the Constitution, which is the highest legal norm of a country. So, the Constitution is the legal text that regulates the establishment, legal entity, organization, the functioning of organs of the government, relations of individuals with the government, and fundamental rights, liberties, and obligations of individuals. The main contract, which has similar features to the Constitution, is one of the requirements for the establishment of the commercial association company. It can be described as a contract which creates the basic order of the partnership, determines its internal and external relations, regulates shareholders' rights, authority and obligations to the partnership and each other. As it can be understood from the definition, the company's main contract regulates main issues related to the organs of the partnership as a legal entity, its capacity limits, its capital, its shares and common stocks, its shareholders and relations with third parties, shareholders' obligations to partnership and each other, and termination and liquidation of the partnership within the framework of the provisions of the mandatory law. In the main contract, which is the official reflection of the entrepreneur and a requirement for the establishment of companies, includes such as internal and external relations of the partnership, preference shares, determination and distribution of advance of dividend, investment, used fraud bonds, jouissance shares. In addition, the main contract focuses on issues such as the election of board members, decision making, task division, representation voting, committees like family council, wages, audit, general assembly, corporate governance principles, foundation for company personnel, contingency reverse, and special contingency reverse. Furthermore, the main contract clarifies subjects such as the election of the next chairman of the companies, the sale of the company's shares to another person or family outside the family, the status of the heirs who are related to the family by marriage or blood. In line with the mentioned, it can be said that overcoming dispute and sustaining company's existence is as important as the existence of company's main contract in order for for it to get started. Especially in times of crisis and growth, this importance increases. The company's main contract has great importance in crisis situations such as the death of the company's major shareholder, non-compos mentis, irreversible coma, their inability to work, their disappearance, lost, their convention as a result of infamous crime, having an illegitimate child, getting divorced, disposal of the company's shares, having an inefficient board. Therefore, the main contract which explains the opinions and expectations of the founding partners is an important tool for managing the risks that may be incurred in family companies. For this purpose, risks must be defined according to the type and characteristics of the family companies, and provisions to eliminate these risks must be added to the contract. Risks change over time. Therefore, with the changing risks, the main contract must also be changed. These studies should be conducted with a team of lawyers and financial advisors headed by the family company consultant who works in the identification of risks. As a result, the possible obstacles to the continuity of the company must be determined without ambiguity. These situations and the possible solutions must be taken legal basis with the main contract. In the management of risks in family companies, in addition to company contract, a testament, inheritance agreement, renunciation of the inheritance, property regime agreement must be used. I would like to briefly talk about what these regulations mean. The testament is a ready-made document or oral statement which is created to comply with legal requirements and the legator's wishes and desires, and the principles of sharing the inheritance of the inheritor shall be explicit. Accordingly, the testament is that it is a reflection of the will of the inheritor and is obligation to be created in accordance with legal requirements. How the inheritance is shared or requires can be included. The inheritance agreement can be defined as a transaction based on the debt between the inheritor and other party. In positive inheritance contract, the inheritor enters into obligation to give his or her inheritance or certain property to a contractor or to a third party. Renunciation of the inheritance contract is the one which aims to prevent the legators from becoming a heir in the future. With this contract, onerous contract or gratuitous contract, probable heir gives up all or a part of this inheritance in the future. Community property, like marriage agreement, is a family law contract that must be done in an official way and regulates how to manage the property of the couples who are planning to get married or are currently married in the event of divorcement or during their marriage, what their rights are and obligations of the parties regarding the goods regime, how the goods will be liquidated when marriage ends. The validity of the mentioned contract is extremely important. For this purpose, it must be regulated in accordance with legal provisions without any doubt. Now, I would like to give some information about corruption. Corruption is based on family social and cultural history. cultural and economic development, bureaucratic traditions, and political origins in the family companies. It varies from country to country, even from one region to another, from family to family, and from company to company. It is difficult to make a generally accepted definition of corruption, considering socioeconomic conditions, political and institutional structure, and other factors. However, different definitions have been made by international organizations. According to the World Bank, corruption is abuse of public power for private interests. Accordingly, if a public official gives or accepts bribe for this personal benefit, it means a public duty is exploited. The concept of corruption, according to the International Transparency Organization, has been defined as the abuse of the entrusted power for private benefit. They made a definition more comprehensive without limiting the concept to public power. The concept of special interest mentioned here is about money or valuable assets. But it also includes the increase in power and status. Now, I can briefly explain about corruption in family companies. Corruption in family companies is the use of money, authority, power, reputation, surname, and all related elements in the interest of the individual and or microfamily, leaving the family and company in the background. In other words, unlike nepotism, which is also called favorism, corruption in family companies is the use of power, money, surname, etc. in an individual's or their family's own interests, the prevention of the application of the rules in the family and or the company, the content of the rules and systems getting affected, and its consequences for the family and or the company. In family companies, we can see that sometimes shareholders, sometimes big shareholders, and sometimes family members who are responsible for the finance are directly involved in corruption. Corruption is the directly measurable variable. However, the number of indices focusing on corruption measurement has increased significantly in recent years. The widely used indices are make significant contribution to the global investors such as Transparency International Corruption Perception Index, World Bank's Global Governance Indicators, Transparency International's Global Corruption Barometer and Global Integrity Scales, and PricewaterhouseCoopers the Opacity Index. There are a number of reasons for corruption. I can briefly express these reasons. Uncertainty in terms of rules, systems, and applications. Uncertainty creates gaps, and if these gaps are tried to be filled within the discussion of the family members, it may cause corruption. Abuse of power. Families and companies have power to enforce for making arrangements, operating rules, operating the sanctions. Family members may choose to abuse this power and impose unfair treatment on other family members and stakeholders. Low income per capita. If she wants to have better living standards and especially other family members, relatives and close friends' living standards are very high, corruption may occur. There is a negative correlation between corruption and poor governance. Profitable companies and wealthy families tend to have less corruption and better functioning administrative systems and administrative structures. In addition, low income levels can be both the cause and the result of corruption. Weakness in the application of property rights and the rule of the law. Weakly defined property rights blur the ownership of the family, company, and individual, and the boundaries between them. The inefficiency of the family constitution and the company's main contract may increase the likelihood of corruption. Closed systems. Closed systems may cause inequality. Closed systems may cause inequality between families and individuals and may threaten the justice. This situation may cause high levels of corruption by taking over ownership and or management of the company. Historical and cultural factors. Certain historical and cultural characteristics of families and companies may lead to a different explanation of corruption for families and companies. For example, in some cultures, gift-giving is a widely accepted behavior, while in some countries it can be seen as a corruption behavior. In the struggle against corruption, family companies should try to find solutions that particularly suit their structural situation. In this context, other shareholders and family members, family companies managers, family management with family members, the interaction should be established, excessive bureaucratic procedures should be reduced, incentives should be distributed fairly, decisions and operations should be based on legal regulations. Furthermore, family and company should work with editors, material and moral rights should be improved. A family form and a family council should be created. Family constitution should be regulated. Work with the family office, assess should be managed. Otherwise, information about the family and the family company should be shared with transparency. Accountability should be paid great attention. Codes of ethics about family and work should be created. Justice should be given importance and systems should be supported with technological infrastructure. In addition to these internal solutions, family companies should also try to make external solutions by cooperating with national and international organizations from outside of the family company. In today's program, we talk about the importance of legal regulation in managing risks and corruption. See you on another show.